So the case of CFMEU and MSS Stategic Medical Proprietary Limited involved an arbitration between the union and an employer after the employee had been issued with a warning, a disciplinary warning, about 8 specific issues that had occurred in the workplace. These included things such as acting disrespectfully to other employees, slamming a fridge door, climbing on top of a water tank when she was out of the premises, in breach of safety procedures. So each of the instances of poor behaviour that were alleged were relatively minor in nature. The CFMEU utilised the dispute resolution clause under the Workplaces Enterprise Agreement to take the matter initially to a conciliation. However, as a result of it not settling, it went to arbitration. And ultimately, the Commission found that each of these instances were relatively minor in nature, and issuing a warning was disproportionate to what had occurred in the workplace, and the warning was removed from the employee's record. Interestingly, Commissioner Gregory referred specifically to the fact that the Fair Work Commission shouldn't second-guess managers' decisions in the workplace. However, he found in this case that a reasonable person in the manager's decision wouldn't have made this decision and wouldn't have issued a warning, and therefore the Commission were entitled to step in the place of the manager and remove the warning.
I think one of the first points that comes out of this case is just a reminder to employers the importance in enterprise bargaining negotiation to not agree to include a compulsory arbitration clause in an agreement. For a moment, leaving aside the issue of the warnings or the substance of it, this just illustrates that if you allow the employer representatives, in this case the CFMEU, to pressure you into a compulsory arbitration clause in these terms, it means, in effect, the employees or their representatives have the power to, in effect, mount a legal case to second-guess management decisions, and that's something that, you know, is not helpful for any employer. So yeah, it is something that is so worth withstanding if you're under that sort of pressure in enterprise bargaining.
I mean, the main issue that was in this was whether the warning was proportionate to the actions that the employee had taken. Usually arises more in unfair dismissal type cases, when the Commission has to look at whether the employer had a valid reason and whether potential earlier warnings were reasonable.
Because in most cases the employer will not have the capacity, because just a modern award-covered employee, there's no capacity to challenge a warning. It has to come after the dismissal. But I mean, it is valid. It's worth noting that if it ever is challenged down the track, if you give warnings for issues that are not substantive and then attempt to terminate on the basis of those warnings, you could still come up with significant issues.
And significantly in this case, the employee had no prior warnings, no prior behavioural issues that had been raised with her. The CFMEU also tried to mount arguments that she was being bullied by her manager and that she was being targeted for redundancy because they were trying to cut back the workforce. But the Commissioner in this case refused to deal with those issues and noted that there were separate procedures in the workplace in terms of complaints that could be made to mount those issues separately. So I think the key thing is really, you know, leaving aside the EA issue of not allowing a dispute resolution clause that lets a union or an employer take it to the Commission. But in any case, if warnings are to be issued, they need to be proportionate. They need to take into account the employee's previous behaviour, the context, and how serious or not serious the issues are.